David Rogers.
You're waiving.
Yes, Your Honor.
So Rogers, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it.
Right off the bat, we've got a defendant waiving a preliminary examination, and that's a big move. This hearing is where the prosecution has to prove probable cause. So here's the question. Is this a strategic shortcut, or is the defense avoiding something deeper?
Yes. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. Yes. People also waive their right.
Yes, Your Honor, there was an offer. Can I place that on the record?
Yes, you may.
The offer was to waive open exchange, not to add habitual offender notice.
Correct, Your Honor.
Correct. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information. We'll waive formal reading.
Thank you.
You're welcome.
Thank you for doing it right. I could count on you. Go ahead.
Thank you, Your Honor. And we would stand mute and ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
At 1:30, the judge will move.
June 22nd, 2026, 1:30. Judge Hamoud.
Thank you.
Bond will continue. Thank you, sir.
Thanks. See you then.
I'll get another one.
Thank you. Call. Recall, let me know. Never mind. We're not talking. Talk to Alan.
For Edward Harvey, the responding officer. I just want to put it in my note purpose. It just deputy.
What is she?
How do you know? How do you know her? I'm sorry.
Court does call the case. People versus Edward Harvey.
Notice how clean and fast that exchange was. No hositashchen. That usually signals pre-negotiation behind the scenes. When things move this smoothly, it often means both sides already know where this case is headed.
And then on behalf of the people, Your Honor. And Stephanie Can on behalf of Mr. Harvey, who's appearing. Could you say your name for the record?
Edward Harvey.
Your Honor, today's the date for the examination. At this time, for unable to proceed as to count one, would ask for count two to be remitted down to district court.
Your Honor, we have no objection to count two being dismissed.
Count one.
Time.
Count one being dismissed.
Yes, count one to be dismissed, Judge Vernon. Count two can't be dismissed.
Being able to count one. Count one is dismissed. I'll continue the defendant's not guilty plea to count two. Set pretrial in this matter for
May 7th at 9 a.m.
May 7th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor. Your Honor, my client has made a request that with the felony being dismissed, if the court would be inclined to allow for his phone privileges to be reinstated. As the court is aware, they initially revoked his privileges based on some communication. I believe information and emails have been received by the prosecutor letting them know that the complaining witness is not willing to move forward on this. And that at that point, she believed that she had anxiety and a psychological issue as an email I received, which was what led to this. So we're just asking that his privileges be.
But his privileges were revoked because the underlying offense was to domestic violence.
Yes, Your Honor.
So that hasn't changed.
Yes, Your Honor, that is correct. That is being remanded down to district court.
Is there a response from the people?
Violated no contact order with the victim by calling her and but unless they remain revoked.
Motion for bond modification is denied. Bond will continue and his phone privileges remain revoked.
Thank you.
Bond will continue. Thank you.
Thank you, Your Honor.
The preliminary examination. Are we ready to?
After the preliminary examination, and this is anything however, after the first asking for 15 minutes, given that 3 minutes amount of discovery that I have not even been able to review as we received it this weekend, and that defense counsel does not have yet. I created a discovery packet for it yesterday in the court. I may remember set this exam last week. And for the people that they may be able to start or continue the exam, based on that, I have concerns given that this discovery includes potential video or surveillance footage of the assault, the victim's medical records, follow-up interviews with the victim and the victim's mother, and then the contact that would be jail calls and screenshots as well of outside contact. And I have not had a chance to review any of that, and I don't defense counsel has either. But this time I would ask you to start the exam with one of our officers, and then if anyone's given that.
Ms. Gaines.
Yeah, so first of all, I have explained all of that to my client. And he is aware that I have started listening to the jail calls, that I do not have the medical records, and that
Go ahead. But just so that I'm clear, these are medical records regarding the child. Oh,
that is true. And anyway, so I have received and looked at some, but I have not received all and have not been able to get through all. He is aware of that. He believes that this is, he objects to the preliminary examination as well as to a continuance because this is the date and time scheduled for the preliminary exam. If the people are not ready, then a dismissal today does not harm the people. A dismissal would allow them to continue their investigation and get all the information they need and not deprive them of his liberty rights while they continue the investigation, as opposed to being ready in the statutory framework.
And Your Honor, just for the record, if the case was dismissed today, the people will be reauthorized.
Yeah, I mean, that's what I was just gonna say. I mean, the reality of it, which is why when people are trying to rush things, it doesn't always work. If I grant your request, your client would understand that, let's say I dismiss it. Within a matter of minutes before he even goes downstairs, they're gonna be back here and it's gonna be reauthorized. And then the whole clock starts again.
Not aware of that. That was just so he acknowledges that and has not asked any question. The other point to our request for a dismissal at this time is that we believe that they are proceeding in this fashion because they are in fact not ready with regards to all of their witnesses.
I'm sorry, say it again.
That they are not ready with regard to all of their witnesses, specifically the complainant, and that this is to prolong this.
Wants to.
He does have.
No, go ahead. Just make sure to hit gonna talk to, yeah, just make sure to hit that.